Hello, good morning, good afternoon, wherever you are. Thank you for joining us for this webinar. This time is about ratification and how to become party of the Nagoya Protocol. So we expect that we will be less in this webinar, and we hope that if we repeat it, we will be even less people attending as the numbers of ratification are growing, and we hope that you join the Nagoya Protocol Club very soon. While we wait to see if there is some extra participants coming, we wanted to take the opportunity to introduce ourselves, the team, in case that you haven't been in one of the webinars before. This is one of the webinars that we do monthly. This is something we do in the unit, in the ABS unit. If you want to join the future ones, you can check also the announcements on the ABS Clearinghouse. And also the recordings of the previous webinars are all available in the Clearinghouse, so you can check the topic that interests you and look at the recording and keep posted to all the activities that we are having. So first of all, I'm Beatriz Gomez. I'm working on the ABS unit, particularly on national reports and assessment and review. And I wanted to introduce the colleagues today with us. First of all, Tauko Shikongo, he's the senior officer for ABS, and he's going to be the lead for this webinar today. Tauko, please.
Good morning to you all. And we also have two other colleagues. Farah, can you introduce yourself? And Gisela?
Sure. I can go first. Hello, everyone. My name is Nusrat Farah. I work as a program management assistant in the ABS unit. Gisela, you can go ahead.
Good morning, good afternoon, everyone. My name is Gisela Talamas. I am also part of the ABS unit, and I work more specifically on the ABS Clearinghouse. And you're gonna see me and Farah and Beatriz answering your questions in the chat. So don't be afraid of asking any kind of questions. Hope you enjoyed this webinar.
All right, thank you. Then I think we are ready to proceed. Good morning, good afternoon, good evening to all of you, wherever you are. And as Beatriz said, welcome to all of you to this webinar on navigating the ratification process for the Nagoya Protocol. The presentation that we are going to be giving to you today is based on the information that we've gathered through the many processes over the years, as well as the lessons and inputs that we have regarding ratification and implementation of the protocol to date. And so it's a compilation of all that we know and does not necessarily reflect the view of the Secretariat. It is attempting to provide a comprehensive overview of the issues that one would face when you go through the process of ratifying the protocol. Just trying to move on. My computer seems to have frozen. Right. Now, with regard to the presentation itself, we have a number of sort of objectives that we will take you through. And then there will be a section that would provide the foundation of the protocol and the ABS. And then we will look at why should you ratify and what has been the lessons learned to date and some of the achievements and that we have received over the years. So today we hope to give you to look at detail into the ratification process for the protocol, and at the same time also create awareness and understanding for the protocol. And we will now move on to look at ABS under the CBD. And what we will see there first is that the CBD was adopted in 1992 to curb, address, reverse, and halt biodiversity loss through its three objectives, which is conservation, sustainable use, and benefit sharing. Today, the CBD has two supplementary protocols, the Nagoya Protocol on biosafety, and as well as the Nagoya Protocol on access and benefit sharing, which was adopted in 2010. Now, if we look at CBD, the ABS under the convention, we'll see that it provides for an equity dimension, access to genetic resources in exchange for the sharing of benefits derived from their use. And so by enabling countries to exercise their sovereign rights to control access to their genetic resources. And that will happen through negotiating benefit sharing terms. And so the intention was to create incentives to conserve biodiversity and to use it sustainably. And there is, of course, also the issue of traditional knowledge as it relates to genetic resources. Now, if we look at the benefit sharing from the use of genetic resources, what you'll see there is that ABS can be seen as a vehicle to achieve the Sustainable Development Goals, social justice, equity, and fairness, impacting on livelihoods of the custodians of biodiversity through the SDGs. If you look at those benefits, they are quite far-ranging and pertains to many of the development issues that are facing countries today. And so moving on, we will look at the ABS under the protocol. This was, of course, necessitated because the provisions on ABS under the CBD were not fully implemented, and therefore parties sought for a legally binding instrument on access and benefit sharing, which led to the Nagoya Protocol. This protocol gives effect to Article 15 of the Convention, and for users, it provides new business opportunities and advancement of scientific research. For providers, it provides opportunities for sustainable development through sharing of benefits, both monetary and non-monetary. For indigenous people and local communities, it provides an incentive for promotion and protection of traditional knowledge. And overall, it contributes to conservation and sustainable use of biodiversity and human well-being. Now, if we look at the ABS as it is addressed within the Nagoya Protocol, we'll see that the protocol rests on three main pillars, and this is now known as the ABC of ABS, which pertains to access to genetic resources, benefit sharing, and compliance. When we look at access, this is asking states to address the concerns of users of genetic resources with regard to their measures that they will put in place for access. And it established an obligation to grant a permit providing evidence that prior informed consent and mutually agreed terms was established before access was granted. With regard to benefit sharing, what we see there is that the protocol builds on the CBD provisions and include a list of monetary and non-monetary benefits that can be shared between the provider and the user. And again, this has to be done on mutually agreed terms. Now, within that, we'll see that there is the issue of prior informed consent. And what is needed there is that the measures must provide legal certainty, clarity, transparency, and then through the rules and procedures that will then be non-arbitrary, must be fair, and on mutually agreed terms. And the information needs to be provided as to how you're going to apply for that, so that the decision can be made that is clear and transparent. And then once the permit has been granted or for access, then that is put in the ABS clearinghouse. We now move on to look at compliance. For compliance, the provisions address the concerns of providers of genetic resources, and this was the key innovation of the protocol, in that parties are to take measures so that users under their jurisdiction respect the ABS agreements or requirements of provider countries. And if we look a little bit deeper into compliance, we see that there are various requirements there. There is the compliance with domestic ABS legislation with regard to access to genetic resources, and of course the traditional knowledge, again, that has to be done with prior informed consent, mutually agreed terms, and also there are compliance measures to address situations of non-compliance or where there is alleged violation of domestic access monitoring legislation. And what is important, states are also asked to take measures to monitor and to enhance transparency about the utilization of genetic resources. And that is to be done through an internationally recognized certificate of compliance. And this is compliance with mutually agreed terms. And then, as we can see there, currently there are 5,679 records of permits or certificates published in the clearinghouse by 30 parties. Now, having looked at sort of the three pillars of the convention, what is the current state of ratification of the protocol? We have 142 parties to the Nagoya Protocol, and the dark green is the Nagoya Protocol parties. The yellow are some of, I think there is no yellow there now, and the gray are the parties who are not yet parties to the CBD, who are not yet parties to the protocol. If we look at progress on ratification, we can categorize that into those countries where the ratification process is underway, and then we've got the countries who are planning to ratify and countries who have ratified, who are 142. Now, once you've ratified, you have to, of course, implement the protocol, the provisions that I've just gone through. And one of the most important provisions is the ABS clearinghouse, which was launched in 2014 with entry into force of the protocol. Now, it plays a key role in the implementation of the protocol, and as it provides and contributes to clarity, transparency, and legal certainty for both users and providers. It contains a wealth of information beyond the monetary information that parties are required to publish. Other information includes also a virtual library on ABS related publications, information capacity building initiatives, as well as community protocols of indigenous people and local communities. Now, the question has to be backed as to why have 142 governments ratified the protocol? What are the benefits and what do they stand to gain? We see that there are a range of benefits to countries or to parties who have ratified. It provides a framework for legal certainty and transparency. Then it is also assuring the fair and equitable sharing of benefits, both monetary and non-monetary, and it contributes to biodiversity conservation and sustainable use through the incentive of the benefits that are being shared, and contribute thus to development, human well-being, and livelihood security. It also contributes to the protection of traditional knowledge at national level. It supports innovation, research, and development, facilitate for academia, research, and industry to engage in research on biodiversity and genetic resources. And then it also help the country to support biodiversity-based business development through investments in bioprospecting and value addition. We also see then that once a party is ratified, it gains access to the Global Environment Facility for implementation support, and then that also opens up other avenues through other agencies that may, donors that may give support for implementation. And should a party decide to host the Conference of Parties of the Convention, then the party also has the benefit of serving as the president of the Nagoya Protocol Conference of Parties, or party serving as the meeting of the parties. That is only though if the president of the COP also has ratified the Nagoya Protocol. If not, then a new president must be elected following established rules and procedures. So it also benefit, or if parties ratify at this point, they benefit from the experience and best practices that has been established in implementing the Nagoya Protocol to date. So there does no need to start from scratch. And the ratification also fosters international cooperation, because we know that genetic resources and biological diversity is has also a transboundary element into it, which may lead to bilateral cooperation as well as multilateral cooperation to address access and benefit sharing. Having said that, we will now turn to the main focus of our engagement today, which is how to navigate the ratification process. Before we look into the process itself, it is important to look at the key concepts that pertains to ratification. We see that there is the concept of signature. Once the negotiations have been concluded for any instrument, then states have to sign that treaty, and the signature only is serving to signal the intent of that party to comply with the treaty, but it is not binding the state. The second step then is either acceptance, approval, accession, or ratification of an instrument. And this is the international act whereby a state then give consent to be bound by an environmental or a multilateral environmental agreement. So we now then delve into the various steps for ratification. The first is that the state must give consent to be bound by the provisions of the Nagoya Protocol. And here it must complete all necessary procedures in accordance with its own national laws and domestic procedures governing treaty ratification processes. And that is then national laws and practices will determine whether a treaty is to be ratified by the executive or the parliament, and as well as the procedures that has to be followed. And questions that comes to rise is also, will the treaty be automatically domestically binding once it enters into force, or whether implementing legislation will be required to translate the treaty into national law. This generally is led by the ministry responsible for that particular sector, in this case, environment. The second step then is to prepare the analysis or preparatory analysis and collection of information and documentation needed for preparatory for the process of ratification. Here, they have to collect the relevant documents, and that may also then include translation of the Nagoya Protocol and looking at what are the costs and benefits of ratifying the protocol. Then moving on, it is important that at national level consultations with relevant government officers who may be impacted by the Nagoya Protocol after ratification are consulted. And these generally includes ministries of foreign affairs or international relations, planning and development, and trade and industry, agriculture, fisheries, etc. All ministries that has to do with issues relevant to the utilization of genetic resources. It would be useful to then consult them and to see whether they also give consent to this ratification process. There are, of course, outlier agencies such as statistics agencies, planning and community development, finance that may also be consulted, as at one point or another they may become relevant to this process. Now, then there is the identification of constitutional requirements and processes for domestic approval of ratification. And here, the national authority that is mandated to decide on ratification, be it whether Parliament or the executive, needs to be approached. And they have the mandate or the authority to identify the necessary steps and procedures that will lead to ratification. And they will also indicate the necessary decision-making organs that must be consulted before the instrument can be signed or deposited, as well as the approval then from the head of state, head of government. Then we have the process for approval of ratification. And again, this depends on the constitutional provisions. Who has the authority to approve? Is it the executive? Is the head of state? Or is it the legislator? Now, moving on, there is the procedures by which ratification will take place. And these procedures generally vary from country to country, but they are subject to parliamentary approval, and they are approved in the various chambers of parliament. And then with prevalence of one chamber in case of disagreement, but in the end, that disagreement must be handled so that there is a consensus and Parliament can then approve that the instrument be ratified. There is also consultation with the government office responsible for issuing ratification instruments, and this normally is the ministry responsible for drafting the instrument, and it is generally the legal office in the Ministry of Foreign Affairs or International Relations, and they can be contacted after approval from Parliament or the executive. And then the last step is to examine the need for the desirability of a declaration. This declaration simply provides the understanding of the specific clauses of the treaty by the ratifying party, and it also then specify the extent to which the treaty applies to the country's dependent territories, should it have territories. Now, then we prepare and sign the instrument of ratification. This is to be done by the responsible office, which is the line ministry, and they will also have to prepare the declaration, and then this is signed then by the head of government or head of states, or the minister of foreign affairs, or any other person that has full powers given by the three to sign on behalf of the state. At that point, then the instrument is lodged with the depository. For the Nagoya Protocol, the depository is at the United Nations headquarters in New York, and the protocol will then take effect for that particular country after a defined period, which is 90 days for the Nagoya Protocol. In some cases, it is necessary to perhaps translate this instrument, this ratification document, in English or French to assist the process. Now, having gone through that, there are a number of factors that need to be taken into account as one goes through this process. And the first one is to see whether there is need to pass implementing legislation, given the fact that international treaties sometimes automatically can form part of national laws once notification to other parties of its entry into force in the country. And the treaty may become immediately enforceable within the country and creates the rights and obligations for national actors even without the adoption of implementing legislation. But in cases where the treaty does not become immediately binding at the national level following signature and ratification, then it must be transposed into domestic legislation to establish corresponding national rights and obligations. And the legislation must be adopted thus through applicable domestic legislation procedures. And it is necessary to avoid duplication and conflict with the existing national legislative framework. And so there are various processes to do that. There may also be a need for a judicial review for situations where the treaty must be submitted for judicial review by a competent national court. And normally this is the Constitutional Court. Only thereafter it can become binding. And in this case, it is to determine the consistency of the treaty with the constitution of the country. And only once that has been done can the process then follow. There are various steps that one can take to support this ratification process. And one of them is the rapid capacity needs assessment. And this is to determine the technical, financial, human, and institutional needs and requirements. And so these then can identify the gaps within existing legislation so that legal and policy frameworks could be amended accordingly so as to accommodate the ABS principles. And this process also then identify things such as do you need support for drafting new legal policy or frameworks, and preparation of briefing papers and cabinet papers for enhancing political synergies, as well as strategic planning to inform amendments and to policies and legal frameworks, and draft legislation for debate and adoption by Parliament. Another very crucial step is the need for stakeholder engagement. And this is broad consultation with various stakeholder groups so as to ensure that their views, concerns are taken into account. And there is particularly a need to focus on strategic outliers. And it is important to have, especially sector, the academic sector, and the Indian and local Indian people, local communities, to also to be squarely at the table, because they constitute quite a large part of the users that will be regulated through this instrument. And then there is need for targeted interventions for creating in-country specialists, since this issue of ABS is a fairly specialized issue, and there is need for synergies, mainstreaming, and integration of ABS in national strategies and action plans. And to do that, it is important to have those that have full understanding of it, and as well as the valorization of genetic resources and traditional knowledge, that you've got a strategy for that and the understanding for that, as well as the understanding of the market of ABS and the market structure of ABS. Then there is the engagement on increased understanding of the ways in which ABS could create strategic business opportunities through innovation, how ABS could harness the economic, social, cultural, and political well-being of both men and women at national level, and the need for measures to ensure and promote trust between users and providers. Now, the process, of course, is also having some challenges, and here we've attempted to put together some of the main challenges that we are seeing. There are policy and regulatory frameworks and challenges around that. We've also tried to provide some potential solutions for them, as we have picked up over the years. There is, of course, the complexity of the ratification process, the issue of political will and lack of consensus between ministries, lack of understanding what the Nagoya Protocol is about and what it means for stakeholders, especially users, the challenges of creating national ABS measures, processes, and institutions, especially the clearinghouse, and the lack of legal certainty, clarity, and transparency in some of the instruments that have been developed. Some of the potential solutions is the need for sensitization and awareness raising workshops, and then ensuring that the policy that are being drafted is quite proactive and incorporates collaboration with other countries and stakeholder groups. And also the need to consider an interim ABS measure that is based on a policy, so that one gain experience before legislating, and then one can address through this experience those issues with legislation. And the need for mapping and reviewing national regulatory frameworks and other instruments to identify gaps in bioprospecting. And again, the issue of understanding the market and market structure. That's to do with the challenge of policy and regulatory framework. Then there is, of course, the issue of capacity building and development that will bring forth need for significant financial resources. And what we've also found is that there is a lack of availability of resources to meet the cost associated with establishing the necessary administrative and regulatory frameworks. And there is quite a challenge in that there has been few capacity building development partners, and that number continues to dwindle. And some of the challenges or potential solutions that we can give forward is that in COP16, the COP 5, the Nagoya Protocol Capacity Building and Action Plan has been adopted. So it has quite a range of measures proposed that one can use for capacity building development. And it is, as said before, necessary to establish a pool of experts and facilitators who can become trainers of others. Translation of the Nagoya Protocol into layman versions in local languages, and a systematic and multi-layered awareness and marketing strategy. And what is also coming to the fore is the need for branding, marketing, and public relations strategy to start seeing the issue of ABS as a business, just like any other business, and not necessarily just an environmental issue. And the need for a variety of means to then disseminate information, training, ABS training, and skill acquisition. That has to be done at both high school level, introducing ABS into that at the tertiary level and also in technical institutions. Moving on, there is perception management and public relations because there is lack of knowledge and understanding by government officials on ABS matters and creating that awareness. Lack of information on national ABS processes and procedures, and the lack of national ABS technical expertise, and very important, lack of clarity of some of the terminology as used in the protocol. For instance, the difference between biotrade and bioprospecting, and understanding the concept of utilization of genetic resources as defined in the protocol, because that understanding will allow you to put in place measures that actually address what needs to be addressed. Then there is the lack of practical experience with regard to the needs of the different sectors and industries that are involved in the issue of ABS. And again, it is in terms of the potential solutions. Perhaps it would be useful to bring in media experts and business communicators, as well as the traditional communication experts. And it's important to bring in measures to build trust between the players at the table. Then I've spoken before about the need for stakeholder engagement and coordination. Here, the GBF provides some solutions, which is foster a whole of government and whole of society approach, ensure that all are on the same page, and again, work towards mainstreaming synergies and integration of ABS into national development plans and programs. Then there is the financial challenges. Funding for the revision of regulations according to the principles of ABS can be an issue, and there is also insufficient funding at domestic level as a result of government prioritizing economic issues over environmental issues. Here, a potential solution is to assure that access is granted so that benefits can be generated, because without access being granted, benefits cannot be generated. And by benefits being generated, you can demonstrate that ABS is actually a trade and industry issue. And there is thus need for discussions with key institutions, government institutions and departments to increase funds for ABS through national budget allocation. And in this regard, it's also important to develop a valorization strategy at national level to demonstrate the economic value and contribution of genetic resources to the national economy and create action plans with guidelines. And that can be done through your considered as you undertake your rapid capacity needs assessment. Now, the final challenge that we've identified is the issue of monitoring, compliance, and reporting. And there is this lack of understanding the monitoring and tracking the use of genetic resources. And there is also been a lack of focus on actually the monitoring the flow of benefits, as indicators have not been developed for that. Again, in this regard, there is need for measures to build trust, and there could be the development of ABS guides for measures and procedures and allowing for access to generate benefits. Now, the issue of indicators was addressed during COP15, when with the adoption of Goal C, Target 13 of the Global Balance Framework, in that it called for an increase in benefits shared. And what that means is simply that if we don't know how we are doing in terms of generating benefits, then we may not know whether we're really implementing the protocol. And so there are headline indicators which looks at the outcome, and there are high-level indicators over all goals and the scope of the goal and targets. And these can be used for planning and tracking of progress during the reporting process. And then there are the binary indicators that are more process-oriented. And part of the indicators also have complementary and component indicators, which are optional, and they serve as proxies for benefit sharing. And these are mostly linked to the requirements parties to publish information in the ABS clearinghouse as required by the protocol. Moving on, and as we move towards the close of the presentation, there are some lessons and an insight that we have seen. ABS is a cross-cutting issue because it's got a trade investment focus, research and innovation development, and it's a social justice issue. If that's the case, then ABS is a sustainable development and livelihood security issue, and thus the need for social capital or building trust, and then also focusing on the need on understanding the need for all users, for them to be engaged, and putting in place procedures that allows reaching at least the negotiating stage of the process. But for that to happen, there must be legal certainty, clarity, and transparency for all. And there is this idea that maybe there is an impasse in the implementation of Nagoya Protocol. However, if that is true, then business opportunities will remain unlocked and the benefits will not flow, and benefits cannot be generated and fared fairly within the legal frameworks. And so there is perhaps a need to look at who should be at the table. Is it really environment sector colleagues, or should it be from trade and investment, science, technology, and perhaps business marketers and branding? Many questions. So we see then that there has been significant milestones within the ABS landscape. The first milestone can be seen as the adoption of the Nagoya Protocol in 2010, because it made ABS a global concern. And the GBF framework and its 4 goals gave us goal C, target 13, that is asking for a transformative change and shift in focus from implementation to monitoring, and introduce the need for indicators. We also saw something that we have not talked about here, the emergence of the DSI negotiation, which has then brought forward that the solution requires a transformative change. And then finally, the global health security also brought forth that ABS is a central concern to global health governance, especially in the wake of recent pandemics, and therefore ensuring equitable access to genetic resources, including pathogens, has been critical for global health security and equity. These are some useful resources on ABS, and if you have questions, we will take them now. We took a bit of time to go through this, but it was quite a topic. Thank you. Are there any questions?
So the chat has been very quiet, so I think it's more maybe, as we are a small group, please take advantage of this occasion to ask a question of the presentation or something else as well. We are here to help you. You can put it on the chat, or please put your hand up and yes. Don't be shy. It's a good opportunity. You have here a good team ready to answer your questions. Paulina from Chile, please.
Hello, everyone. Can you hear me?
Yes, we can hear you.
Okay, perfect. Thank you for the presentation and for all the links that were sent in the chat. I already said all of them. I wanted to ask if there is any like companion from the secretary to the party meanwhile is doing this process and steps for ratifying Nagoya Protocol. Like if we state somehow, I don't know, for example, a letter or something like that, that we would like to start with the process of ratifying Nagoya Protocol, is there any like a person named to be with the country in this process, like answering questions or maybe doing some talks, or I don't know, just guiding a little bit the process? Thank you.
Can you have one more question?
There is
Karen.
Karen.
Yeah.
Yeah.
Good evening to everyone. My question is about the. Let me go back to the start of discussion. I was a little bit late. I'm sorry, maybe you answered this question already. My question is about the signification of the protocol, as it was open for, was reminded to sign until 2012, as I know, until February. And I couldn't find any legal acts that this timeline was changed.
Sorry,
So
can you speak in the microphone, and can you be, I didn't quite get the question.
Don't you hear me?
Yes, proceed. What is the question?
About the signification of protocol. As I know, the timeline, deadline of signification was until February of 2012. And I couldn't find any legal act that changed this timeline.
Okay, timeline.
Mm-hmm.
And that timeline that you're saying was for, is it for, you're saying certification or ratification?
It's for the signature.
Signature.
Yes.
Okay. All right.
We have another question. Maybe you want to take this as well, and for the moment. So, Sadie, please.
Yes, good morning, buenos dias. Hi, Talco. Wonderful presentation. Thank you so much. I wanted to ask about your thoughts on legal personhood, essentially the recognition of rights, protections, and responsibilities towards animals, plants, ecosystems, national entities, or natural entities rather. And I wanted to ask your thought, just to expand maybe a little bit on what you were sharing towards the end, on problems and solutions that you were offering, and where that conflict is between protecting the environment and then other perhaps competing interests, and maybe how legal personhood is or maybe isn't yet playing a role in implementation of the Nagoya Protocol and other principles.
All right. Yeah, thank you for all the questions. If I start with the question by Corona from Chile, with regard to assistance, we will note that there are standing decisions by the meeting of the parties for Secretariat and Jeff to continue with activities to support funding and activities to support implementation and ratification of the protocol. And that is exactly why we are having this webinar to provide those who have not yet ratified with the necessary information that we may have to help them in this process. We, of course, also send out letters to all those who have not ratified, asking them to provide us what is the status, what do they need, and how can we be assisting. I am the person responsible for ratification, so please do simply reach out to us, and we'll find a way to see what we can do in that regard. The question about signature, yes, generally there is a time frame within which parties can sign, but if that window of signing is over, that is why in the definition part, I talked about the signature definition and then ratification, acceptance, approval, etc. The signature was simply to signify or signal the intent to ratify. And if at that time, when it was open for signature, you have not been able to do so, there is nothing that prevents the country then to accede to the protocol in the end. That is why accession and ratification or acceptance approval following the processes that I have already outlined. So even though that timeline is done, you're no longer able to sign, but you are able to accede to the protocol. With regard to the issue of legal persons, I think the foundational principle and understanding within both the convention and the protocol is the principle of national sovereignty of state over their natural resources, which gives the legal nature over biological resources, including genetic resources, in that states have authority to determine access to their genetic resources, Article 15, and based on the conditions that I've outlined, one, prior informed consent, which is associated also with traditional knowledge, Article 8J, and mutually agreed terms that provides a basis for achieving the third objective. Now, the issues that you are raising, Sadie, around the legal persona, that legal persona, of course, must find themselves within that fundamental principle of national sovereignty of states over their natural resources and including their genetic resources. And so that falls in the realm of other, the question that you are asking about animals, like the plants, etc. They all fall under that principle at national level if that legal person exists within a defined space and time of a sovereign state. Beatrice, do you want to add to that?
No, I think you did a very good answer. And it's a difficult question. No, but I think that was as much as the Nagoya Protocol, this is what we can answer about this. We have still some time, 5 minutes. I don't see any other hand, but please, if you have any other question, I let you a second to come forward. Also, just to remind you that now that you know us, that you have seen our face, that you have talked to us, we are available to help. As Tauco was saying, he's the responsible person for ratification, but here Gisela also works with the ABS Clearinghouse. I work with the National Report. So if you have any question at the moment, we can guide you to the appropriate resource or to answer the specific question itself later on at the email that Gisela shared, abschcbd.int. Any other question? Okay, Tauco, if you want maybe then to close this webinar.
I see still a hand from Sadie. Sadie, is that a legacy hand or is it a question?
I don't know how to take it down. I apologize, but thank you so much for your response to my question. I really appreciated, understanding your perspective on where it falls under the Nagoya Protocol and the existing principles to support it. Thank you. I don't know, someone lowered my hand.
Thank you.
Thank you.
Yeah, thank you all. And so thank you all for having come to have some more insight and understanding on the Nagoya Protocol, what it is, what the benefits are, and what the process is of ratifying and the challenges around that, and the milestones that it has achieved for those who have already ratified, and that today it provides the minimum standards for benefit sharing, and out of which most of the work now has emanated. And of course, Nagoya Protocol does not exist within a vacuum. There are also other international instruments that are regulating access and benefit sharing in their own sectors. And that is also part of this whole architecture of ABS. And also noting that there are some articles that are still the modalities are still being worked on or developed by the parties for implementation. Now, yes, we available, and do reach out to us, and we'll see what we can do, whether it is to provide inputs into your workshops or to just assist with questions that you may have. Reach out, and we'll see what we can do within the limits of resource availability. With that, thank you all so much for spending the time with us this morning, this afternoon, this evening. Muchas gracias.
Thank you.
We will share the recording of the meeting once it's available, and some of the resources as well. That's what you wanted to say, Gisela?
No, yeah, I was going to say that you're also going to be receiving it by email with all the list of resources that were shared in the chat. So just give us a couple of days and you'll be getting this by email. Thank you, everyone.
Thank you. Bye.